I'm told into river Yamuna.
Right. That's correct.
I'm also told that this petitioner hearing has criminal antecedents. That is why I'm seeking some time to file it.
You're for the state?
For the state.
Just one thing that I wanted to bring to your lordship's notice. There was an order of no coercive step. However, in the interim, charge sheet was filed and even court took cognizance, my lord. On this regard, my lord, I'm just passing an order of your lordship. Whether when no coercive step has been ordered by the court, whether cognizance or charge sheet can be filed against that accused, your lordships have taken over. If I may be allowed to pass this, my lord.
No, it can be taken. No coercive means no arrest.
No arrest.
That's practically. But other proceedings may go on.
Very well, Lord. I just wanted to bring to your lordship.
Are you up
this order, however?
Let's sit on record.
Very well, my lord. I'll do that.
Learned State Council is allowed 2 weeks' time to file counter affidavit. Post on 7th. Sorry, 7th to 7th. Post on 4th February.
Please.
Interim order.
The interim protection will continue.
Interim protection granted to the petitioner will continue till the next date of hearing.
I'm extremely grateful.
Item 7.
Lordships, this is a bailable offence. I've been granted bail on the date of arrest, but I have applied for the custody certificate, and due to vacation, I haven't received the custody certificate yet, and I will receive it within 2 weeks.
304A.
Pardon? Lordships, I've never been named in the FIR, nor nor a TIP was conducted.
TIP? What is TIP?
Test
There are
identification.
so many witnesses who have seen you driving the vehicle.
Lordships, the examination was conducted after
In
3 years.
304A matters, the accused is never named in the FIR.
Lordships,
Because after committing accident, they run away.
no, Lordships, the examination was conducted after 3 years, 4 months. There is
nothing
a high
in
chance.
the matter.
Lordships, there has a high chance of
No.
the examination of the.
No, there is nothing. There is a concurrent finding against you by all the 3 courts.
Lordships, no evidence with respect to the width of the road or its shape or density of the traffic.
That is not required.
No photograph of the alleged vehicle has been recovered, and not the passengers who were riding on the auto. They were.
Why have you not surrendered?
Lordships, I have been granted exemption from surrendering.
You have been granted exemption?
Yes, Lordships. And
Exemption from surrender granted to the petitioner. No, we are not continuing the exemption
Lordships,
granted to
my
you.
daughter is suffering from a very rare disease.
Somebody has died, elder daughter is suffering, and some fever, some viral fever.
I deeply
We are not concerned. We are not concerned.
To the incident, but
IA number so and so seeking exemption from surrender is rejected. Petitioner shall surrender within 2 weeks.
Lordships may kindly grant 4 weeks to surrender.
4 weeks. Post on. It is better for you to remain for some time so that eventually we may consider reducing the sentence further.
Deep your
No, it is in your interest.
Deep your
11th March.
Item 8.
May it please, minutes.
Yes.
Minutes, eviction under the Public Premises Act minutes. I was given the
You have
permission
not been
minutes.
paying the license fee since 1988.
Minutes, I may submit.
Yes.
Actually, about 4,000 people were given notices, a sort of a mass eviction.
So therefore, you will stop paying.
Some contested, some have not contested. As far as I am concerned,
No,
minutes, it was 1977.
That 4,000 issue that got over in the first round of litigation.
My plea, the plea that's been taken by the petitioner before the authorities was this, minutes, that he had been making all efforts to pay that one. The authorities refused to take
Who
that
will refuse?
so that minutes, because
Who- no,
they could have a ground to
who
evict.
see? government's window is
Yes.
always open.
Millets, when it comes to meager
Government window, who,
with the
which officer in the government or any public sector undertaking will refuse
with the
any money which is offered to the PSU or the
Yes.
government?
with the expansion of
It's not
cities
acceptable.
and towns, millets, these lands have
It is not
assumed
simple
value.
landlord tenant
So
that
they are-
landlord will refuse to pay except the rent.
Millets, when it was given in 1970s, it was a remote area. Nobody bothered. That's why all people may have had their settlements and their businesses, whatever. In this case, a timber depot. Now, millets, with 50 years passing, they have become part of urban agglomeration, other things. That's why they refuse to take, and then that could be a ground for them. And also, millets, a technical objection, if
There are
you
several
mind.
rounds of litigation, two,
Yes,
three rounds. Why did you not offer any time? If you are not paying, they were not accepting, you could have sent
Precisely, millets.
a bank
No,
draft
it's
to them.
Though it's a plea on my part that I've
That
tried to
plea
offer, rather
is
than
self-service,
refuse, I could have taken remedial steps once they are not accepting. That burden is on me.
Now, you see, 12 plus 26, 38 years you have been.
Yes. Well, if my lords give us one window of an opportunity, we are willing to make good the entire amount, as we have said that they've not
No,
been
it is for
refused.
them to.
accepting.
We cannot regularize you. If the licensor
Yes.
is not willing to continue the license,
Yes.
court will not thrust upon the licensor that you should accept you as a licensee if you have violated the terms.
2 minutes. May I add one point to that, 2 minutes? As my lords could see at millets, the page number 32, the license or whatever that's been granted, I was permitted to raise structures, and I have raised structure.
No, kacha.
And then millets section
That
60.
I was examining that license.
Yes.
You were entitled to raise kacha structure. You have raised pakka.
Millets,
Everything.
millets, may I submit one thing, millets? And my lords have read more than I could imagine. That's the correct one that I was.
57,
Yes, millets.
para 9.
Yes, millets. I am at it.
Something shall construct
The
it.
LRT shall construct, I marked it, millet. The LRT shall construct
And you have raised a
temporary
pakka.
murder brick.
Because it is in
water.
the urban agglomeration.
The allegation that
Very
millets now
difficult,
have made
Mr.
that structure.
Naidu.
Yes, millets. Millets, may I pray,
difficult
millets?
case.
May I be given 6 months' time to vacate, please?
That can be
My plan B.
Lord, in June, 4 months' time was given. Already,
residential premises.
50, yes, millets.
He will search for some other location and shift his
I
business.
have.
Lord,
Timber business.
on last page, the Honorable High Court.
We'll allow him 6 months.
My Lord, may give 2 months. My Lord, the Honorable High Court,
You are not a businessman.
only one submission.
You are
My Lord, in the
a
month,
steel company.
my Lord, in the month of June, 4 months' time was granted. So from June onwards, already 7 months have passed. So my Lord may give 2 more months, my Lord.
6 months.
Great. Deep breath.
My Lord.
I can't ask for more minutes.
Upon hearing Lord Senior Counsel appearing for the petitioner, we are not inclined to entertain the SLP. However, in the interest of justice, the petitioner is allowed 6 months' time to vacate the premises. And hand over vacant possession to the respondent number.
Lord, Bokharo Steel Limited, my Lord.
No, there are so many respondents.
I think.
Who's the respondent?
On number 2.
Respondent number 2, Bucharest Street.
On number 2. Accordingly, it is directed that petitioner shall vacate the premises. Today is 15 January. On or before 15th of July 2026. The petitioner shall submit usual undertaking before the registry of this court.
Will submit.
Yes.
Grateful. Deeply.
सर मतलब आप पूछ रहे हैं कि आप 2 बजे बेंच लेंगे
Notice of the bench.
हाँ 2 बजे अभी उनका कॉल आया उनकी कोर्ट से नहीं लेंगे
Good enough.
I like it.
Your Lordship, in item number 9, if Your Lordship may recall, this matter was also taken up before vacation.
Yes.
Primary dispute here is with regards to the date as to which the pay scale for trained teachers will be given to the untrained teachers after they complete the in-service training. And Your Lordship, the rule position is very clear at page number 47, which says it should be from the date of
There is some
publication.
similar matter is also pending.
Your Lordship, the similarity is not there. It has been mistakenly been added because that matter pertains to the requirement of the training as per the NCT regulations. Your Lordship, may kindly have page number 47. This is the particular rule which I'm relying on.
Right?
47.
So we thought that it is similar matter. We have not properly gone through. Anyway. Yes.
Your Lordship may have clause 15D. Page number 47, Your Lordship. This is the relevant service rules for the teachers. The rule says that untrained teachers' facility of training determined by National Council for Teacher Education shall be got available by the state government to teachers completing successfully training from date of publication of result. Salary of trained teachers shall be payable. So, Your Lordship, what happened in this case, a single judge in another case decided that the date should be from the date of completion of training instead of date of publication of the result. And pursuant to that, the department was directed to grant the benefits to these teachers as on the date they complete the training. However, since the rules were not taken into account, since the rules were staring at our face, we granted them notional benefits from the date of completion of training. However, the financial benefits were granted from the date of publications from the rules, which is as per the rule 15D. Now, what happened in the second round of
the High Court has granted it from the date of completion of training.
Yes, Your Lordship.
And not from the date of, you say it should be from the date of declaration of result.
Yes, Your Lordship. Now,
why it should be from the date of declaration of result? If you declare it after 10 years,
Your Lordship, actually,
and it is training only.
Your Lordship, there was a difference.
They were already in service.
Your Lordship, both the courts proceed on a premise that I have delayed. However, they didn't take in the nature of examination.
Where is the appointment order?
Your Lordship, that will be at page number 67. It starts from 66. The effective para is from page number 67.
67. Let us read.
Your Lordship, if I may only read the effective part or the entire part?
No, the relevant part only.
Yes, Your Lordship. The relevant paragraph.
Or you will start reading from the Department of School Education, Bihar, file number. So
really, Your Lordship. Sorry. So, paragraph number 6, Your Lordship, as per the Bihar Panchayati Elementary Teacher Employment and Service Condition Rules 2012. Para 6, Your Lordship. Yes, Your Lordship. Pay scales of trained and untrained teachers is separate. As per rules, only to teachers who have obtained prescribed training eligibility, trained pay scale is payable. Para number 7, keeping in view aforesaid facts, in compliance of the order passed by the Honorable Patna High Court, untrained teachers enrolled in session 2000, Your Lordship, there's an error, it should be 2013-15, whose training is complete in May 2017 and who have passed under the results published in March 2019, from the date of completion of training course, theoretically sanctioning pay scale of trained teachers.
This is not the appointment order.
This is not the appointment order, Your Lordship. This is the order I passed pursuant.
Which is the appointment order?
Your Lordship, the appointment order is not on record. The order on which they were given the trained scale initially, which was under challenge, was brought on record.
What the appointment order says?
Your Lordship, there is no dispute with regards to their appointed. They were appointed as untrained teachers in 2011-2012.
What about the pay scale?
Your Lordship, the pay scale, the rules.
In the appointment order.
Your Lordship, it should be as per page 45. That was the rule position. That is the pay difference in the pay scale for trained and untrained teachers. Rule number 15.
There is no, you see, anomaly or illegality in the High Court order.
Your Lordship.
Because they have completed the training. It is your fault that you declared the results after 2 years.
Your Lordship, it is actually not my fault, and I may explain how. Because the appointments in this particular case are done at the district level at the panchayat. These are the panchayat teachers which are being appointed.
Yes.
Now, the training of all the teachers cannot be done simultaneously. The training of teachers are done in a phased manner, depending on different aspects. Now, the examinations were conducted 1 year after the training was concluded. After the examination with the 4 months, I released the result. However, it was the very nature of this examination because it is being conducted at a pan-state level, despite this being at a district level appointment, Your Lordship.
Thank you so much.
Your Lordship, Your Lordship, on the last occasion, Your Lordship,
we heard you, and then we thought that probably we may give you some more time to examine.
Your Lordship, there will be grave financial implications for the simple.
It has to be.
Your Lordship,
in every case of teachers in any state, the financial implications are always huge because the teachers are in thousands and lakhs in every state.
Yes, Your Lordship.
Even if there is 100 rupees difference, it will.
Your Lordship, we have given them the notional benefits by taking that into account. Even beyond the rule position, what we could do, we have done that. The rules were never under challenge.
Despite vehement submission made by learned counsel for the petitioner, we are not inclined to interfere with the.
Your Lordship, if I try one more time, one last minute. That's it.
Yes.
Your Lordship, one last point in
Yes,
this
yes.
regards is this.
Yes.
Your Lordship, the rules are never under challenge, and I am bound by the rules. And I have taken into account the single judge order and the rules position and
What
balance.
about Kishore Kumar?
Reconcile.
Kishore Kumar.
Yes, Your Lordship. That's the single judge order. It does not take the rule position into account at all. It is only on the basis of the.
You cannot differentiate between Kishore Kumar and Muhammad Rafi. Once you have allowed Kishore Kumar,
Your
you
Lordship,
have to pay it to Muhammad Rafi.
and that's why I accepted
Thank
it.
you.
But I have given a notional benefit.
Thank you.
Great.
Delay. There is delay.
Delay conduct.
Item 10.
But here I was not heard ever. Audi alterum partem is the rule, my lord. I was never heard. And kindly have paid C, my lords. When my mother was the original tenant, then I filed section 7(1).
7 years delay.
My lord,
7 years delay.
no, my lord, 5 years delay. And the
No, no,
delay
7
was
years.
not-
High Court says 7 years.
My lord, it is
Order was passed on 16/4/2018.
that was coming to the High Court, my lord. That I have explained, my lord. Page I, my lord.
Huh?
That I have explained, my lord.
The,
Well,
the miscellaneous appeal order was on 16/4/2018.
Yes, my lord.
And you filed a revision in August 25.
25, my lord.
Hmm.
Well, there was a COVID-19 period was there, and thereafter my husband underwent major surgery. Therefore, I was financially and physically strained. This is the problem. That is
That cannot be around 7 years.
my lord.
Howsoever major the surgery is,
My lord. But I was never heard, my lord. My petition was always rejected due to
it was all
delay,
the
my
more a good reason you should have come at the earliest.
my lord.
Thank you, thank you. Dismissed.
I'm sorry.
Item 11.
I'm seeking 2 weeks' time, Your Lordship. A German
Is the letter, though, Milots,
the settlement talks.
we are settling it also, Milots. So, Milots, Lordship may adjourn it by stand over by 2 weeks.
Shall we record that you are settling?
Yes, Milots, on the previous occasion also jointly we have said that.
Petitioner has moved letter for adjournment, which is not opposed by learned counsel for the respondent on submission that settlement talks are going on between the parties.
Yes.
Post the matter on 18th February.
Item 12.
Lordship, I appear for the respondent. The mediation has failed.
Failed.
Yes,
Okay.
Milots.
Then what next?
Taking a short Passover in this matter.
Hmm?
Short Passover.
Pass over.
Item 13.
My lords, I'm seeking a transfer from Family Court Indore to Court of Competent Jurisdiction in Jhansi.
Yes, respondent is not appearing.
Yes, my lords. He has already served as per the office report in October 2025.
Yes, respondent sir not appearing allowed.
My lord.
Item 14.
Your Lordship, sir, I seek a short pass over. The main counsel is on legs in court number 17. I seek a short pass over.
Pass over.
Item 15.
Yes.
Mediation has failed,
Failed.
Lords.
Failed.
The petitioner, Lords, herself filed an understanding before the court, Lords, in the case what she's seeking a transfer, Lords. She was ready to settle the issue.
So is there any possibility of mediation being
Mediation could
conducted
be
again?
for
Yes, sir.
if some
One
senior
more time.
mediator is
One
appointed.
more time.
Exactly.
Some senior.
Because what the mediator says that not agreeable to arrive at a settlement at this stage. So I
Now she want to settle all
thinking
this.
why at this stage? Means there is some possibility.
If she wants to
Sometimes in
settle,
future.
she wants to settle, Lords, I have no objection, but the husband cannot live with her. It could be in for the separation only. Whatever. So the amount which she agreed upon was 10 lakhs. initially she agreed and then.
See, mediation doesn't mean that it will be only for reunion.
Yes.
It can be for.
And she herself has filed an application on Section 10 Hindu Marriage Act. She has filed an application in Section 10 also for judicial separation. So she also doesn't want to stay with the boy, and the boy also doesn't want.
Some possibility.
So if one more chance could be given, appointing senior mediator laws, so it could be settled.
The mediator's report records that the parties are not agreeable to arrive at an amicable settlement at this stage. At this stage, को inverted comma करना है. Full stop. Para. In course of hearing today, learned counsel for the parties submit that another attempt can be made to arrive at amicable settlement. They would also request that if a senior mediator conducts mediation, it will be beneficial to both the parties. Considering the request made by learned counsel for the parties, the matter is again referred for mediation to be conducted at Supreme Court Mediation Center. Who heads the center? It is superintendent or what?
Mediation center.
Coordinator. The coordinator, Supreme Court Mediation Center shall consider appointing a senior mediator to mediate between the parties. Post the matter, the parties shall appear before the mediator on 30th January. 30. The matter may post this matter on 24th March along with mediation report.
Very good. Bless.
Item 16.
Please, my lord. My lord, this is a transfer petition, my lord. The petitioner is 70 years old. She was married when she was 9 years old. She was married, my lord, when she was 9 years old. Today she's 70 years old.
70?
70, my lord.
And she was married at the age of 9.
Please, my lord. My lord, she was born in 1956.
So what is this matrimonial proceeding after 61 years of marriage?
After 50 years, my lord's husband has taken an ex parte decree of divorce. My lord, she's filed an appeal, my lords. My lord, she
what
lives
is the age of the husband now?
My lord's 88, and my lord, he's in a living.
88 only.
My lord, he's in a living relationship, my lords. If my lords may turn to page number 51, he's living with some other woman.
Then live out.
My lord, he admits that. My lords may turn to page number 51, para 21, my lord. He admits that.
Very interesting case.
That's para 21, my lord. Para 21, my lord, at page number 51.
There is already an ex parte divorce decree has been granted.
Please, my lord. My lord,
what is pending now?
My lord, she has filed an appeal, my lord. The ex parte decree was
ex parte divorce
in my lord's Bilaspur. My lord, it's pending at the High Court of Chhattisgarh, my lord. She seeks transfer to Indore. She's 70 years old, my lord. She suffers from intentional tremors, my lords. And husband, my lord, is a retired railway employee.
What is pending in High Court?
My lord's my first appeal against the divorce.
First appeal? There was no application for setting aside ex parte decree.
No, my lord, she has not moved that.
So how can it be set aside? If there is an ex parte decree, the first you have to approach the concerned court for setting aside the ex parte decree.
I bow down to
that. For an appeal,
bow down to that, my lord.
You received the summons from the court?
My lord, she did receive the summons because my lord, the order
yes,
was...
if it is a court, if it is a case of non-appearance after receiving the summons, then appellate court can do nothing.
Yes, I'm only seeking...
It's a wrong step taken by you.
Well, this is
only the same court which has passed the decree you should have approached.
Well, this is a legal aid matter, my lord.
Legal aid means what? Law will not change for legal aid matter.
No. Well, I'm only seeking transfer of appeal, my lord. From my lord, this is.
No, it can't be. Why should it be transferred?
My lord, 819 kilometers away, my lord. She doesn't have any source of income, my lord, to even contest this
No,
appeal.
High courts will always be at some distance.
No, she lives in Indore, my lord. The High Court is at Indore. My lord, the husband admittedly, my lord, earns 76,000 rupees. My lord, may turn to page number 50.
No, husband
earns 76,000 rupees every month, my lord. She is my pension, my lords. And my lords, he's living with someone else, my lords. My lord, she only seeks liberty to contest the appeal, my lords. That's all, my lords. The High Court is 819 kilometers away. I'm not seeking any order on merits. Let's make
required to appear in the High Court.
She has,
argue your case.
She has to engage a lawyer, my lords. She doesn't have means, my lords, to try. She doesn't have means, my lords, to engage.
Legal aid, like you are appearing, some legal aid counsel will appear in the High Court also.
Let me turn to page 29, my lord. She has several medical issues as well.
She is not required to approach. You have already filed an appeal in the High Court. You must have approached your counsel for filing the appeal. The same counsel will argue your appeal. You are not required to go there.
My lord, she's an old lady, my lord.
Any chance of mediation?
My lord, the respondent is not appearing, my lord.
Not appearing.
We have been served.
Before this ex parte divorce, that was granted in which year?
Well, it's 8th of July 2015. 2015, my lord. My lord,
2015.
Well, she came to know in 20.
Before that, you were staying together or?
Well, separately, my lord. She lives in Indore with her daughter.
Since which year you have been staying separate?
Well, since 2000, my lord, 11, 12. But
2000?
2011, my lord.
11?
Please.
Any issue in the marriage?
Well, they have 2 children, my lord.
Two children.
She's living with the daughter, my lord.
They are married or they are not married?
They are married, my lord.
They are married. Both the children.
Both the children. The issue is, my lord, she doesn't have any financial. My lord, she came to know about the divorce, my lords, in 2025, my lord, when she applied for maintenance. As my lord has read, my lord, he admitted being in a live-in relationship, and then he disclosed that he has taken a divorce decree. My lord, she was married at 9, my lord. She's not worldly wise. She's not educated, my lord. She was not able to contest the matter properly.
Where is the decree for divorce?
What is the judgment, my lord? Starts at page number 23, my lords. Para 5, my lords, page number 25, para 5, my lords. We page that the case became ex parte because she did not appear.
Page number?
It's page number 23, my lords. The judgment starts, the divorce judgment. Page 25, para 5, my lord, says that due to the absence of respondent on date of hearing, that is 4/12/2013, one-sided action has been taken against her and reply has not been presented on her behalf. And my lord, on the pleading of the husband, my lord's divorce was granted. And she was not aware of this order, my lord.
You did not appear after filing Wakalatnama, it seems.
Malas, no Wakalatnama was also filed. There was no Wakalatnama. No Wakalatnama was filed, my lords. In fact,
what is mentioned in para 5?
That's what she told me, my lords, on instructions, my lords, I'm stating. So that she sent a letter to the court that I'm not interested in getting a divorce. Then, my lords, the husband told
आवेदिका के सुनवाई दिनांक 4/12/13 को अनुपस्थित रहने के कारण उनके विरुद्ध एक पाक्षिक कार्रवाई की गई. सुनवाई में अनुपस्थित, that means you appeared through a counsel and thereafter you remained absent.
My lord, she merely sent a letter, my lord. I can pass, my lord, if I could pass. What she made, my lord, what she tells me is that she merely sent a letter to the court, my lord, wherein she stated that I don't want a divorce. Then, my lord, the husband told her that the case has been withdrawn. Because even in the maintenance case, my lord, he says that in 2019, I paid her 5 lakh rupees, my lord. Why would he pay her any money, my lord? they have taken a divorce. My lords, may turn to page 59, my lords, para 15.
And some lawyer is appearing.
But it's not on her behalf, my lords.
No, on her behalf. See, page 44.
Please, my lords.
The order sheet of the High Court. So and so for the appellant.
In the High Court, my lords.
Yes, in the High Court. In your appeal, you have presented the appeal through a counsel.
Please, my lords. He has one. Well, she doesn't
I should not say that I know the counsel. And this counsel can properly argue your case.
She was not aware of the decree of divorce, my lords, because she came to know about it, my lords, in the maintenance case only. That is why, my lords, there is a delay in this.
No, it is your appeal.
It is my appeal, my lords.
Of which you are seeking transfer.
Please, my lords.
And you have presented the appeal through a counsel.
It's non-representation, my lords, is in the divorce proceedings, my lords.
Very difficult to transfer an appeal pending in the High Court where you are not required to appear personally. Sorry, dismissed.
It's 819 kilometers.
Dismissed.
My lords.
Item 17.
Yes, Lordship, this is a transfer petition. We are seeking for transfer of petition moved by respondent under Section 9 of Family Code, Uttar Pradesh to Rohini Court, where execution petition is pending, filed on behalf of petitioner. Our Lordship.
Execution?
Yes, Lordship, in respect of the petitioner had moved a petition for maintenance.
No, it is
Item 7.
restitution of conjugal rights matter.
Yes, Lordship. The respondent has moved a petition in the
In
section.
Rohini, your maintenance case is
Yes, yes, Lordship. Execution petition.
yes, none appears for the respondent. Allowed.
Item 18.
Lordship, we have received the copy of the counter. We wish to file the rejoinder. The
2 weeks for rejoinder.
Obliged.
Item 19.
Please. Lord, when this matter was listed on 18th of December, we at the outset made a request that we are ready to for mediation. My lord was pleased to refer matter for mediation fixing 21st of January, which is yet to arrive. But my lord also gave certain directions. One, that the petitioner will continue to pay the respondent current interim maintenance, and also said that the areas will be cleared within 4 months. Now, my lord, when this order was uploaded, we found...
No, it is only about 4 months or 4 weeks?
No, this is also about the clarification, because...
Not the other clarification. Interim means interim, what the High Court has fixed.
My lord, then...
What you are submitting in your application,
Please.
that interim should be read as what the trial court has...
For the sake of, my lord, mediation, because if my lord...
You can only say that instead of 4 weeks, it should be read as...
Yes, then mediation...
Not beyond that. Not beyond that.
There will not be any result coming out of this mediation, because she will not...
You are not concerned.
Nobody will be ready for...
For you to decide any settlement. If you...
But there are...
4.5 years
they have not paid.
We cannot trust any mediation or any settlement.
I appreciate that, my lord. But we, from our side, my lord, we are making endeavors to settle the matter. But if she...
See, if we... Do you mean to say that if we stay the interim maintenance, the matter will be straightway resolved? Therefore, kindly...
And there will be some scope of negotiation between 75,000 to 1.5 lakh. Now, if my lord...
Number so and so has been preferred, seeking modification of order dated so and so, to the effect that the time allowed for payment of areas of interim maintenance should be read as 4 months instead of 4 weeks. On due consideration, prayer for modification is allowed, and it is directed that the petitioner shall pay the entire areas of interim maintenance within a period of 4 months from so and so. Wait,
1812.
1812.
Not from today.
No, not.
My lord, 1 month is already over.
1 month is over. So you should have.
And mediation.
You should have paid something in the last 1 month. Since it is 4.
We are also in this application, we are also making prayer that this,
one second. That interim maintenance is.
This 1.5 lakh should be made 75,000. Otherwise, my lord, there is no scope for negotiations. No settlement.
Don't negotiate. Who is saying? Who is compelling you? We are not compelling you to negotiate.
Not at all, my lord. This was, of course,
It's your problem.
outside our submission. That
It's your problem. 4 months from that date.
my lord, kindly appreciate this. Kindly make it
Made clear that petitioner shall pay interim maintenance at the rate allowed by the High Court under the impugn order. Yes.
This matter is for release of vehicle. Release of the vehicle which was involved in a motor accident causing grievous hurt. I am for the state of Jharkhand, my lords. My humble submission is, my lords, that High Court has basically dismissed the criminal revision on the ground of concurrent jurisdiction. That because the order was passed by the court of JMFC, therefore the appeal, the revision in the first instance ought to have been filed before the Sessions Court. And Malas, they have relied upon their own judgment, which Malas has not.
You're on merits.
Malas, then Malas, on merits, I have
here interim custody only.
Malas, I'll make submissions on merits also then. Malas, the owner of the vehicle died in December 24.
His son, other family members have granted NOC.
Malas, but what is relevant here is that the accident took place in April 25. Under the Motor Vehicles Act, ideally, my lords, these vehicles, and it's not just one truck that his livelihood depends upon it. There are at least 12 trucks which he is running off his father on the basis of a notarized special power of attorney, not even registered. Under Motor Vehicles Act, my lords, this has another aspect which will need to be considered, that within 3 months after the demise of his father, he continued to run these commercial vehicles without taking any steps to make himself the registered owner. And my lords, today also he is not the registered owner.
In which proceeding, in which FIR it has been seized?
Malas, that's the
what
first.
Is the offence committed?
Malas, grievous hurt. Some driver was rash driving. 18th April 25 is the incident, the reported incident in FIR. Father expired in December 24. 22nd of December 24.
And your RTO should have seized all the vehicles, 12 or 8.
Malas, the only involved incident.
Why have you not seized that vehicle? If he is operating those other vehicles also,
Malas, those
without being the registration being transferred.
Malas, those came out for the first time before this honorable court.
Forget about this honorable court. Now you are submitting.
Malas, only in this honorable court.
Forget about this honorable court and this vehicle.
Yes.
According to you, he has 8 vehicles belonging to his father, and all the vehicles he is flying on road on the basis of some affidavit or some power of attorney.
Power of attorney, yes, Malas.
You should have seized the other vehicles also.
Malas,
rather than allowing the other vehicles to ply on road and commit another further accident.
Malas,
you are making all technical arguments in this case unnecessarily.
Malas,
Take. The High Court, leave granted. The High Court has refused to grant interim custody of the. What is this truck? Tata, what truck? What Tata truck? Which make? 407.
Cargo trailer
vehicle. 16 wheels, what?
Malas, 18 wheel cargo trailer vehicle.
18 wheel Tata cargo trailer vehicle.
Bearing registration.
Which has been seized by the concerned police in connection with offence under section 438 and 442 of Bharatiya Nagarik Suraksha Samhita. Where is the offence mentioned?
It is in FIR, Lords, at page 14.
Page?
14 of the SLP, Lordship. Annexure P1.
Connection with offence to be.
Under section 281, 125.
Malas, this under 281,
125A and 125B.
281, 125 within bracket small a and 125 within bracket small b of BNS, not BNS. BNS. Full stop. Admittedly, the vehicle is owned by petitioner's father. And on the date of the alleged offense, the vehicle was not transferred in petitioner's name. To stop. Considering that other family members have no objection to the petitioner seeking interim custody of the vehicle, we are inclined to allow interim custody of the subject vehicle in favor of the petitioner for the simple reason that in the event the trial takes longer time, the subject vehicle, being a mechanically propelled vehicle, would lose its value and it will be of no use for the either for the petitioner or for the respondent state, in the event the vehicle is confiscated. Accordingly, the SLP, the appeal is allowed, and it is directed that subject to petitioners submitting personal bond and surety for a sum of rupees 5 lakhs. What is the price of the vehicle now?
Lordship, as per the insurance, the valuation given in the insurance.
5 lakhs, 5 lakhs before the trial court within 1 week from today. Within 1 week or 2 weeks?
2 weeks, my lords.
2 weeks from today, the subject vehicle shall be released in favor of petitioner. During pendency of the trial, the petitioner shall not dispose of or create third-party interest on the vehicle and shall not commit any other offense and shall not be involved in any other offense concerning the vehicle. Yes, next.
Lordship, the vehicle number may be mentioned if in the order, my lords.
Vehicle number mentioned.
JS02 JS02BS. It's at page 24 of the additional documents. The no objection certificate.
You already mentioned the interim order also. So it's
Yes, in the interim order also.
well ordered.
JS02BS 256.
PH02BS 256.
Yes, my lords.
15/12/2025.
Deeply obliged, my lords.
21.
If I'm appearing for the caveat and all, I'm seeking a passover. I'm being led by Mr. Siddharth Dave.
21.
Yes, sir.
Password.
Lordship, please. Sir. I'm the tenant holding over.
Yes.
Should I pass the
all 3 courts? How much time?
Lordship, sometime. Taylor. 6 months.
6 months already.
Already given.
Allowed to you.
Yes. Another 4 more months. Well, undertaking here this time.
Considering that the petitioner has suffered eviction order passed concurrently by the what is called rent control authority.
Rent control.
Passed by the rent controller. By the rent controller, the appellate authority and the High Court. We are not inclined to entertain this SLP. Accordingly, the SLP is dismissed. However, the petitioner is allowed 4 months' time from today to vacate and hand over the possession of the subject premises to the respondent landlord. Petitioner shall submit undertaking before the registry to the effect that he shall hand over vacant possession on or before 30th May 2026. Yes.
May please lodge.
Lordship, here, respondent number 1 is convicted under section 302 and he has been suspended his sentence and bail is granted when he just undergone 3.5 years. Lordship, what waited to the mind of the Honorable High Court is that this is a case of single blow. But actually, that is completely incorrect. There were multiple blows were given on the head of the deceased by a stone, as well as paver block and trident.
Where is postmortem report?
Just see, evidence of doctor is there. Postmortem I annexed in additional document. But if Lordship will see page 88 is the doctor's evidence. He mentions the injuries. Page 88 injuries, Lordship can see. Surgical stitch mark 10 centimeter into 0.5 cm. Shaped present on right frontal parental temporal scalp. Second injury 20 cm into 0.5 cm involving left frontal partial temporal scalp. There are internal 6 injuries are internal also. And 89, kindly see the cause of death given by the doctor. Death is due to head injury and its complications. If Lordship will see page 114, how the Sessions Court has dealt with this, that will make a clear.
Only 2 injuries.
No, Lordship, if Lordship will see, there was a CT scan and this was a surgery was performed on his head. Therefore, it is seen prima facie 2 injuries. But there is a CT scan report which gave 8 injuries, which I annexed. If Lordship will see the trial court's judgment at page 114.
No, you have seen, you are showing us page 88.
Page 88.
Page 88, paragraph 2, called clause 2 injuries.
Yes.
Only 2 injuries are mentioned.
Two injuries, and there are some internal injuries.
Multiple injuries.
There are internal injuries, but if Lordship will see 114.
Neither High Court has decided it finally, nor we are deciding it finally.
Yes.
Whether it is 2 or 3 or multiple or internal or it is only suspension of sentence.
But only 3.5 years. There is a case of eyewitness. Lordship will see 114, page number 114. Kindly see. Para 28.
114?
Yes, Lordship. Para 28.
Yes.
After going through the evidence of record, I find that Basuki Nath Jha assaulted Jitendra Nath Jha on 1921 by stone, paver block and trishul over the head of Basuri Nath Jha. I further find that PW Ken, who is doctor who examined Jitendra Nath Jha on 1921 and examined CT scan report of Jitendra Nath Jha, found several injuries on the head of Jitendra Nath Jha. One, extradural hematoma in left temporal lobe, thin subdural hematoma. Third injury is a small hemographic contusion, and fourth is a linear fracture in left temporal partial bone. Although in his cross-examination, doctor has admitted that he has not compared injury found on the body of injured with CT scan report, who themselves not fatal to the prosecution case, because all the 4 injuries mentioned in CT scan appears to be internal injury and only to be detected by doing the CT scan. I also find that PW11 after alleged occurrence of 1921, Jitendra Nath Jha was admitted to the hospital. And if thereafter Lordship will see page 116, then the conclusions are recorded by the learned session judge. He said, keeping in view the several head injuries caused over the head of Jitendra Nath Jha as a result of Great.
We will not deal with your argument in detail because otherwise it may.
Yes. Appeal is
affect
So one submission, our presence be
upon
marked, we are
hearing
not
the
taking
counsel
online.
for the parties, we are not inclined to entertain the SLP. Accordingly, the SLP is dismissed.
Sir, one submission, our presence be marked, they are not taking online our presence. Our presence.
Physical presence.
Okay.
Great.
May it please. Manoj, in this case, it pertains to an intermediate recovery of an NDPS Millet's contraband. Was the brief facts of the case are on 16/4/2024. Was the petitioner was apprehended.
Press case.
Please, Manoj. Manoj, the arrest is vitiated since. No, Manoj.
For alleged recovery of 12.24, 12 kg, 250 grams ganja within bucket intermediate quantity. Bucket loss. The petitioner is in jail since 16/4/2024. It is submitted by counsel for the petitioner that for alleged recoveries. It is also submitted that petitioner has no criminal antecedent. Issue notice.
I'm most fair.
Item 25.
I appear on advance notice in item 25.
Item 25, this is case of anticipatory bail. Milord. My name has been disclosed by the main accused in the disclosure statement. Milord, the total quantity which is recovered from the main accused is 1 kilo and 800 grams of poppy husk, which is not a commercial quantity. Number one. Milord, then
yes,
please. Now, Milord, the main accused has already been granted bail. Milord, we have annexed the order as speaking. Milord. Now, Milord, as far as the antecedents are concerned, Milord, Government Counsel says before the learned special judge that I have 15 FIRs against me, which is an incorrect statement.
2 + 7.
2 + 7, Milord.
Yes.
2 FIRs, Milord, under NDPS and 7 under
Even
excise.
1 is sufficient.
Very well, Milord.
For anticipatory bail, even 1 is sufficient.
I'm on the disclosure statement of the main accused. She has already been granted bail.
Main accused is the wife. Lord's main accused is the wife.
Antecedent.
Not antecedents.
Not only on
regular
quantity.
I'm on the bail in 2 NDPS, Milord, and 7 excise act. Milord, I'm on the
It's only because of that you are committing this crime.
Milord, acquittal.
You have been granted bail in earlier 2 cases. You are continuing, and this is Punjab.
So that's a presumption, Milord. Not that what has learned special judge as well as the High Court order.
What presumption?
Say not already on regular bail in those NDPS.
Sorry.
Milord's main accused is the wife, Milord.
But she has already been granted bail. Main accused, Milord.
Point venture.
Yes, Milord. My friend is not saying that the main accused is the wife of the petitioner here, and he's saying he's insisting on being that co-accused.
She has already been
from the same family. Everybody's there. They have a nexus going on.
That shows they are moving well in life. Yes.
Milord's appearance may be taken.
Yes.
Yes.
A case of state, my lords.
This is the matter, my lord. Implicated only on the basis of suspicion.
Duplicate?
Implicated.
Implicated
only on the basis of suspicion. First thing. Second thing is that the alleged incident was happened on 5/8.
Antecedent also.
Antecedent. There are antecedents.
Yes.
Made a chart also. But the other part is that the investigation officer taken me into custody on 5/8. Now produced me on 9. That is another aspect apart from the merit. In the remand report also, in the CCTV footage Panchanama also, that is very specific.
Early morning. There is no eyewitness, my lord. This is a case of circumstantial
Is the
evidence.
recovery against him?
Lord, Lord, remand report mentions there is a blood-stained axe recovered from at his BS, my lord, at page 40, my lord.
You file counter and point out the evidence.
I'll file it, my lord.
Issue notice. Returnable on 10th February. 10th February.
Grateful.
Mr. Counsel?
Yes,
इनका नाम लिख लेना
Samrat Shinde. I'll give my appearance.
Physical appearance.
Yes, Mr. I'll give.
Mr. Samrat Singh, the Council appearing for respondent state of Maharashtra, undertakes to file counter affidavit, waives notice and undertakes to file counter affidavit before the next date of hearing.
Samrat Shinde.
Item 27.
Lord, item 27 reflects, my Lord, a very shocking state of pattern emerging. This is one incident. Lord, I have narrated in past also, whenever statutory authorities exercising statutory powers of investigation goes there, Lord, the Honorable Chief Minister barges into the premises of the wherever, my Lord, this is conducted.
How is this maintainable?
I'll, my Lord, come to that. Lord, the officers, my Lord, Director General of Police, the Commissioner of Police, they accompany her, they are accomplices, they, my Lord, abate the offence, and thereafter, my Lord, I'll place on record, I have prepared it, my Lord, they sit on dharna, the uniformed service officers sit on dharna with political leaders, my Lord. Now, my Lord, on maintainability. Lord, maintainability, there are two petitions, my Lord. One by the Enforcement Directorate and another Enforcement Directorate along with one officer, my Lord, who is personally agreed. He is a citizen of India. And, my Lord, there is a second petition by two individual officers.
28.
Yes, my Lord. And I have, my Lord, narrated earlier incident also where Joint Director CBI's house was ransacked, my Lord. It was gherowed by people, my Lord, stones were pelted. He was giving, my Lord, frantic calls to survive him, to my Lord,
Yes.
Here, my Lord, there was an evidence leading to, my Lord, a conclusion that there is some incriminating material lying in one premises of a company and premises of one individual. My Lord, the officers exercising powers under section 17 of PMLA goes there. They intimate the local police that we are going there. The Honorable Chief Minister, who is joined as a party, along with the Director General of Police, along with the Commissioner of Police, along with the DCP of the area, and large police force goes there, barges into the house. Whatever material was collected was taken over unauthorizedly, which according to me, my Lord, I have not hidden anything, and I am not feeling shy of saying it's an offense of theft. It's an offense of, there are several offenses, my Lord, which I have mentioned. She takes it away, including, my Lord, one of the mobile phones of ED officials. And, my Lord, thereafter, there is no question of, my Lord, my proving it. The respondent number 2 goes before the media and says that this is the great thing I have done. Lord, if this is, my Lord, turning a blind eye to, Lord, this kind of things will continue, which will encourage not only the people in public life, it will encourage the officials, my Lord, to not discharge their duty. They would, the central forces will be demoralized and the state forces will feel that, yes, we can go with the Chief Minister, we barge into somebody's premises, we collect the evidence, we commit theft of the evidence, and thereafter, if needed, we will sit on dharna also along with the Chief Minister. So, my Lord, I am moving an application seeking a specific prayer that let that example be set, that the officers who were admittedly present, my Lord, during our exercise of powers under section 17 be placed under suspension, and, my Lord, let there be, my Lord, a departmental inquiry, because this is a serious misconduct, even department.
So you want us to suspend?
My Lord, your Lordships may direct the competent authority to suspend. That's the prayer. Now, my Lord, we approach the High Court. Please see, my Lord, what happened in the High Court, my Lord, page 1.
There is no such IE, we have not read this.
No, my Lord, it is filed, e-filed. Lord, I have the copy, my Lord, they are served.
Served at 8 o'clock in the morning.
Yes, yes, it is served, my Lord, it is served late.
I'm not disputing that.
I'm not saying it is served late,
Yes, yes.
but it is, my Lord, filed. Please see, my Lord, my prayer. Lord, this is something very, very serious, your Lord. May please take, my Lord, cognizance of what is happening. Lord, first, see, I have quoted section 54 in, my Lord, context of the officers. Section 54 at page 5. Your Lordships gets, my lord, page 5.
Yes.
My lord, this is PMLA Act, section 54. Certain officers and others to assist in inquiry, etc. The following officers are hereby empowered and required to assist the authorities in the enforcement of this act. One of them is officers of the police. And here police comes along with the chief minister to ensure that the evidence collected is removed by them under their supervision, under that threat. Lord, please have a look at, my lord, the prayer. The prayer, my lord, on the same page. Pass an order or direction placing under suspension respondent number 3, 4, and 5 and any other police officer present during the raid conducted by the Enforcement Directorate on 8th of January 26. Direct the newly implemented respondent number 7 to 9. That is, my lord, the Chief Secretary and, my lord, their cattle controlling authorities, my lord, which I am seeking to implement, to initiate departmental inquiry proceedings for major penalty. But, my lord, right now, my lord, we are concerned, my lord, the pattern is this. Lord, I have given the examples and I'll take your lordships to those examples, shocking examples. Lord, earlier the CBI officers go. Lord, they do not go on their own. There is a judicial order passed by this honorable court directing investigation into some cheat fund offences. Lord, there is a discharge of their duty. The police officers are, the CBI officers are arrested and taken to the police station. The chief minister comes at the residence of the then police commissioner, who happens to be the director general of police today, and stages a dharna on the gate so that nobody can enter. The CBI officials, armed with, Lord, the order of this court under an obligation to investigate in a different offense, Lord, are not permitted to do that. There are, Lord, there was a bail application, my lord, and I'm placing, my lord, those pleadings on record. There was a bail application of the law minister of the state being, one of the accused, a very prominent leader. The sitting law minister goes inside the courtroom and sits there with a crowd of 5,000 people shouting slogans. So there are several things, my lord, we want to show. Even in this case, my lord, this is the position. And, my lord, another thing, my lord, kindly, my lord, appreciate.
Yes, 1 minute.
Yes. Lord, kindly see what happened in this particular case. Please come to page 121. Lord, we approach the Honorable High Court. Page 121 may be seen. This is what happens when mobocracy replaces democracy. 121. This is what the Honorable Judge of the High Court, Lord, records in a judicial order passed. The matter is taken up for consideration. At this juncture, a huge number of learned advocates as well as other persons enter the courtroom and create enormous disturbance and commotion. Request made by the court to maintain the decorum and dignity of the court so as that the matter can be taken up for consideration fell on deaf ears. The environment in the court is not conducive to commence or continue with the hearing. In view of such situation, my lord, the court says it's not conducive for hearing. In view of such situation, this court is constrained to adjourn the matter. Let the matter appear under the heading new motion on so and so.
Yesterday.
No, my lord, this was earlier. Now, my lord, your lordships, my lord, our innocent guess would...
Ninth, my lord, ninth.
It's
Yesterday
ninth.
the hearing took place, there was no ruckus.
Yes, yes.
Yesterday the hearing-
I point out what happened. I was there.
I was there, I saw what happened.
You should not have been there.
Deliberately.
Why should I be there?
I was
Why should I
prevented
be
from
there?
speaking. My mic
I
was
saw it,
Only a
it is
minute,
on
only a
video.
No.
It is on video. I saw the video later
Mr.
in the
Simple,
day.
My learned friend.
Here itself.
Yes, exactly.
Yes, my lord, my learned friend vehemence.
Let him.
Lord, I understand.
Your
Lord, yeah, our
Don't put any ruckus here. Please continue.
no, my lord,
Please continue.
our my lord, innocent thinking can be after reading the judicial order of the learned judge that maybe because of the sensitivity of the matter, the lawyers may have gone. Some people, other people also may have gone out of curiosity, and that might have resulted into an unintentional kind of a chaos and chaotic situation. I have placed on record the WhatsApp chats that the Lord, the law wing of the party in power, my lord, of which the chief minister.
Intentional or unintentional, but the High Court has recorded something.
Yes, my lord, and this was not, my lord, this was not spontaneous. My lord, they were all instructed by the legal cell of the parties to go there. That is page 119, my lord. This is, my lord, the WhatsApp message, my lord, one of the WhatsApp message from the legal cell of the party, my lord. Today on 9th January, court number 5, item 10. Come everyone. Lord, he is convener, Mr. Amit Kumar Das, convener, High Court. Then, my lord, second, gathering today at 1 p.m. at B gate.
Come everyone, as if it is Jantar Mantar.
Yes, the court is converted into Jantar Mantar. Lord, kindly read the second part. Today 9-1 is the first. But today 9-1-26, court number 5, item number 10, come everyone. But this matter, which the learned judge records on 9-1, which your lordships have read at page 121. Next, gathering today at 1 p.m. at B gate, come everyone, will go to the procession of the Honorable CM so-and-so. Bus and vehicles are arranged. This is the, my lord, preparation. Yesterday, my lord, the Trinamool Congress, the party in power, filed a petition. In that, before the petition comes for hearing, look at the position in the High Court. The Honorable Acting Chief Justice then had to pass an order that nobody will be permitted to enter in this courtroom except the lawyers appearing, and it will be live telecast. It was only because of that, my lord, precaution that some hearing took place. That also, my lord, was less than, my lord, satisfactory. My learned my lord, senior friend appeared, and my lord, we faced several difficulties. I don't wish to say that, my lord. Here, if needed, we'll file even an affidavit. His mic was being constantly muted. Lord, these are, my lord, the issues. Your lordship,
But mic is in the control of the court.
Lord, Lord, I don't wish to go into it, my lord. This is a petition for seeking protection of my fundamental rights. We are officers. My lord, the ED is not an organization only. My lord, under section 7 and 8, whatever, my lord, we recover, we don't recover for our personal purposes.
Yes. This, what is he handed over?
But it is this instructions issued by the court.
Yes, my lord. This is something very rare. Even the Honorable Chief Justice is aware that it otherwise cannot be, matter cannot be heard. This is the position, my lord. Now, please see, my lord, the act. What is ED, my lord, on the maintainability? Let me satisfy your lordships. Lord, please come to page, section 8 of the PMLA. Lord, what is the role of ED in the scheme of the PMLA Act? No, it's not just an organ, merely an organ of the union government. Lord, we exist for this purpose. That's what, my lord, I'm trying to show.
Subsection 8 of it.
My lord, section 8, your lordships have?
Yes.
My lord, adjudication. Please come to subsection 8 now. Now, my lord, we do everything. We, my lord, attach the property. We take the property in our possession. Thereafter, confiscation proceedings, etc. Ultimately, what? Who is the ultimate beneficiary? Please see section 8. Where a property stands confiscated to the central government under subsection 5, the special court, in such manner as may be prescribed, may also direct the central government, please mark, to restore such confiscated property or part thereof of a claimant with a legitimate interest in the property who may have suffered a quantifiable loss as a result of the offence of money laundering.
Subsection?
8, subsection 8 of section 8.
Yes, yes.
I'll read again, my lord, for your lordship's convenience. My lord, we go far through.
Where a property stands.
My lord, first is attachment, thereafter, my lord, taking possession. All, my lord, there are some provisions for appeal, etc. But eventually, when it is confiscated, my lord, this is what happens. The victim gets the benefit of this laundered money. My lord, that's what I want to show. Where a property stands confiscated to the central government under subsection 5, the special court, in such manner as may be prescribed, may also direct the central government, please mark, to restore such confiscated property or part thereof of a claimant with a legitimate interest in the property who may have suffered a quantifiable loss as a result of the offence of money laundering. Now, my lords, what we do, my lord, just to give an example, so that I am showing my, my lord, locus to approach your lordships. Because I represent, my lord, those victims. My lord, suppose I am investigating money laundering in a bank. The bank goes in, my lord, liquidation or something happens, my lord, to the depositors. My lord, this amount which we collect will go to those depositors. My lord, the ED has so far, my lord, collected more than 30,000 crores and which are given to the victims of the crime. So we are not just an organization. My lord, we represent the will or, my lord, the interest, not if not the will, of those victims of the offence to safeguard their interest. But, my lord, petitioner number 1 is the enforcement directorate. Petitioner number 2 is an individual officer. My lord, we are now, what they do is, there are 3 FIRs filed against us by 2 by the Honorable Chief Minister, 1 by the police against us, that we did something illegal, we browbeated them, etc., etc. Based on, and this is something very shocking, based on that FIR, they came to the scene of the offence which they committed and removed the CCTV footage.
So what for you went there? And what?
Under section 17 for seizure, for Manoj, kindly see, search and seizure.
What was under investigation?
Yes, Manoj, please come to page B. Please come to Manoj, page B, second para.
Page?
B for Bombay.
B for Bombay, Manoj, my synopsis. Manoj, they say that we went for collecting SIR data, Manoj. A fool will not go to collect SIR data, which is available on the website. B. The petitioners are constrained to approach this honorable court under the most extraordinary, unusual and unfortunate circumstances emerging from the petitioner. As pointed out in detail hereunder, the petitioner is investigating a multi-state money laundering offence under which the proceeds of crime to the tune of rupees 2742 of 0.32 crores are derived from the illegal coal mining.
This offence, this particular scam is being investigated.
Yes, by us, my lord.
And this you went inside.
Yes, my lord. Now please oblige me by coming to page 5. Page 5. This offence is being investigated. Page 5, para 5. Para 5. Page 5, para 5 at the foot. During investigation, it was gathered that the illegally excavated and stolen coal used to be sold in Shakambari group of companies. On analysis of the documents seized from the premises of so-and-so, so-and-so and so-and-so, it is revealed that so-and-so group used to receive cash from so-and-so group against sale of illegal excavated coal. So-and-so group of companies are primarily into steel manufacturing. The group is led by so-and-so, who is the managing director of so-and-so limited and is also director in other group companies. From the evidence collected by the petitioner, it is evident that coal used to be purchased by so-and-so group of companies owned and controlled by so-and-so from coal syndicate led by so-and-so. The payment for the coal used to be made in cash. The so-and-so has not complied with the summons issued for recording his statement under section 50 PMLA. The act of purchasing illegally excavated coal from so-and-so constitutes offence of money laundering in the hands of so-and-so and so-and-so. It was therefore proposed that residents of so-and-so and corporate office of Shakambari Group be searched under section 17 as they have committed an act which constitute money laundering and are in possession of records relating to the offence of money laundering. Further investigation regarding the utilization of proceeds of crime was undertaken, which revealed that the proceeds of crime generated from coal sales were utilized by sending the proceeds of crime through both domestic and international hawala. One such hawala operator used by coal syndicate to transfer proceeds of crime has been identified from WhatsApp chats of so-and-so. Hawala firm name so-and-so was used for hawala transfers by the coal syndicate as seen from the WhatsApp chats. Intelligence was received that around 20 crores of proceeds of crime from Kolkata to Goa was transferred through so-and-so firm. The employee who handled the hawala transfer at so-and-so is so-and-so. Material evidence has been gathered which disclosed that 20 crores of proceeds of crime arising from illegal coal mining were used through interstate hawala networks layered through a chain of felicitations, converted into cash at Goa and channeled into, now please see, IPAC. This is
not felicitation, it is facilitation.
Facilitation, I'm sorry. It means the meaning changes drastically. I stand corrected. My apologies. IPAC's operational framework. This is IPAC where we went and for search under section 17 of the Act. Operational framework by being handed over to persons executing its work. Thus, the search proceedings were started at 10 different premises situated in Delhi and Kolkata on 8th January 26. Out of the said 10 premises, one of the premises was the
same iPad with which earlier Mr. Prashant Kishore was associated.
Yes. 10 premises. One of the premises was the residence of Mr. Pratik Jain, situated at so-and-so, Calcutta. Sri so-and-so assistant director was authorized by Sri Bansal, deputy director, with the authorization number so-and-so to carry out the search and seizure proceedings at the said residential premises of Mr. Pratik Jain under section 17 PMLA. During the course of such proceedings at the office premises of Messrs. Indian Pack Consulting Private Limited and the residence premises of Mr. Jain, certain police personnel has arrived at their respective premises and asked the officers conducting the search to intimate a local police station if they wanted to continue their search. During the course of the search at the residential premises of Mr. Pratik Jain.
This authorization the officers were possessed of.
Yes, my lord, we showed they got not. As a matter of fact, we intimated them in advance by mail. Even on that day, it was shown.
The person in charge of the premises.
Premises also that this is the authority under which we are coming, and we are not interested in any of your political activities, if any. We are confining only to this, my lord. But I do not know what was there to hide that such a drastic step has to be taken that the Chief Minister herself personally barges into it, along with the Director General of Police and Commissioner of Police and DCP and the entire police force. Then, further, during the course of the search at a residential premises of Mr. Pratik Jain, situated at so-and-so on 8/1/2026, various digital devices were taken into possession which were suspected to be relevant to the PMLA investigation. During the course of such search, at around 11:15 a.m., Sri so-and-so, Deputy Commissioner of Police, South Kolkata, visited the building premises and informed the authorized officer that a complaint of house trespass has been received by the police. Thereafter, for the verification of correct facts about the proceedings, the DCP was shown the identity cards of the team and the search authorization letter. Thereafter, Sri Manoj Kumar Verma, IPS, the Commissioner of Police, Kolkata, also entered the premises as the police officers were being briefed about the search proceedings under section 17 PMLA. At around 12:05 p.m., Ms. So-and-so, sitting Honorable Chief Minister of the West Bengal, duly identified, entered the premises despite making categorical requests for not interfering with ongoing search proceedings under PMLA. However, violating all law and order, Ms. So-and-so, with the aids of police, forcibly took possession of all digital devices and incriminating documents from the possession of authorized officer, Sri so-and-so, Assistant Director, and left, he is the petitioner before your lordship, and left the premises at around 12:15 p.m. All the proceedings have been recorded in Panchanama, duly drawn at the premises on 8/1/26, An incident report dated so-and-so was also drawn at the said premises by the authorized officer who was conducting the search. Lord, please see the totality of this. Section 17 authorizes the search. The person searching has the authority later. The people who come, my Lord, the DG, police commissioner, everyone is shown those things. That these are our identity cards. This is our authority later under the statute. And they have, my Lord, this, Lord, I'll not use any adjective, my Lord, but courage to take the incriminating material in their custody, which is a theft. Go and, my Lord, thereafter publicly declare that this is what we have done. And this is not the first time this has happened. My Lord, kindly take this, my Lord, so that once and for all, my Lord, this is decided. And my Lord, IPAC, whose premises is search, has not filed any complaint or even petition or any proceedings that my privacy was invaded, etc. He could not have, because it's a statutory search under section 17, but he has no complaint. But everyone, my Lord, is fighting. Yesterday, my Lord, there was a petition filed by the party, the Trinamool Congress. And my learned senior friend, my Lord, appeared, Mr. Raju, and he said,
What are these photographs we have filed?
Yes.
yes, staging of dharna, etc. Surrounded by the officers, which they ought not to have been there.
Is this incident or some other incident?
This incident. These are the colored photographs, my Lord. You are not placed colored photographs. I undertake to place colored photographs on record.
There is some
Kindly
color,
have colored photographs.
some color, some black and white.
No, my Lord. My apologies, my Lord.
No, there are colored also.
Yes, my Lord. These are this incident.
81, 82, 83 is colored.
In a lighter vein, Millet, some truth is colored and some is in black and white.
There is nothing in lighter vein.
In a lighter
This is everything very, very serious.
I just have to smile. I need to respond. Don't be too angry.
Smiling, but unfortunately, it's
After all what you have said.
We listen notice, Mr. Sibal, this is very serious matter.
Yes.
We have to examine this.
I'm sorry?
Sorry. Mic was off.
Yeah.
We are issuing notice.
Yeah.
And we want to examine this. This is a very serious matter.
We have, your lordships will hear us, Mullahs, before doing that.
Yes, please.
Yes, Mullahs. I just want to, Mullahs, let me first clear the air, Mullahs.
Yes.
Mullahs, who is IPAC? And I'm sure they know about it.
No, I'm sorry, just because there are two.
I'm appearing for respondent number 2,
And I'm
who
for
is
one
the chairman, of the Trinamool Congress.
I'm for one.
Right?
The chief minister
and the police department.
happens to be the chief minister.
Happens to be, yes. But I'm appearing as chairman of the.
Chairman is never
If you don't please, I did not
only
interrupt you.
Only a minute. When you say chairman,
I did not.
Chairman of a party is never accompanied by the director general of police.
Allow me, sir, to argue before.
My Leonard will not decide who we are appearing for with great respect. How will he decide that?
Mr. SG, please allow them to argue.
No, certainly.
Allow us to argue.
No, I didn't know who appears for whom. Therefore,
Yesterday this has been done by your.
yes.
But so we'll come to the issue. According to me, is maintainability. Your lordships will have to decide that the High Court cannot hear this petition for reasons that I'm sure your lordships will give. And if the High Court can hear this petition, then why should your lordships hear it?
No, we are very much disturbed with the way High Court has been almost.
No, the hearing took place yesterday, Mullahs.
Yesterday, but what happened?
But that's not going to be repeated. That's not going to be repeated, Mullahs. The question doesn't arise. If it took place yesterday, it will take place tomorrow also. So your lordships will have to now assume that the High Court can't deliver justice. Fine, but I'm not saying don't. But Maharaj, your lordships will have to say that, Maharaj.
You cannot put words into our mouth.
No, no, I'll say your lordship.
Assume and what we will not
No,
assume
if
is
your
our
lordship,
business.
of course,
It's possible.
of course, but I'm not saying, Maharaj, your lordship.
Please argue your case.
I'm going to argue, Maharaj.
What we will.
My argument at the initial stage is
proceed
that
with your argument.
this matter should be heard by the High Court. Because the High Court is the court which has the 226 jurisdiction. It will hear the matter, render findings on the basis of whatever they are arguing there, Maharaj. We have a right to appeal, and then we can come to this court. That's the hierarchy of courts, Maharaj. And they are now filing parallel proceedings, not wanting to go to the High Court. And their argument is on the last day, that on the 9th of January, there was a ruckus, and therefore proceedings could not take place, which is correct. And then on 13th of January, the Chief Justice passed this order. And then yesterday, a hearing took place, and the hearing was peaceful, Maharaj. There is nothing to assume that the hearing cannot take place, Maharaj. That's point number one.
Yesterday, Mr. Mehta's client sought time, saying that we have filed in Supreme Court.
Yes, yes.
High Court, can I finish, please, sir? So the High Court said, we are adjourning it sine die, with liberty to come back the moment you think the Supreme Court is over, etc. So yesterday, without any ruckus or any involvement, they sought adjournment specifically on the statement, which is why the yesterday order was passed. That's only a fact which should be noted by your lordship, and they said that the matter is coming today.
Correct. Now, Maharaj, on the contentions on facts that he has made.
Yes.
Maharaj, IPAC, we all know, Maharaj, is an entity which takes care of the elections in West Bengal. A formal contract has been entered into by the party with IPAC way back in 2021. And I assume, Maharaj, that the ED knows about it.
No, elections in West Bengal are conducted by IPAC or by the election?
No,
Commission?
all the material. There's a confidential material for the purposes of this agreement. Confidential information shall mean any and all information, including but not limited to sensitive or non-public information of any nature whatsoever. There's a whole series of data, of documents, of information, of facts. All that is confidential, and it is kept there. And I'm sure that the ED knows about it. We knows about it. So when they went there, they knew that there's going to be a lot of information in respect of the party, the candidates, what is happening, what is the program, where we are going to go, what we're going to do. I'm sure they knew about it. So, Maharaj, the first question that arises is, why was the need to go there in the midst of an election? Why was the need to go there in the midst of an election? Now, Maharaj, in the coal scam that we are talking about, Maharaj, the last statement in the coal scam was recorded on the 24th of February. 24th of February, 2024. What were they doing in 2024? What were they doing in 2025? And why were they so keen in the midst of an election in 2026? And we're saying we want for what? SIR for what? It is all the information that's in the computer. Once you get possession of that information, how are we going to fight the election? So, Maharaj, which is why the chairman, Maharaj, the chairman has the right to go. It's the property of the party. So the chairman then went, because they went to the house of IPAC, the individual Pratik Jain, in the morning, in the morning, at 6:20 in the morning.
Yes.
ED went at 6:20. Chief Minister only came at 12 o'clock, Maharaj, and went away at about 12:15.
They collected everything in it.
Maharaj, this is, you can make any statement you want to make, Maharaj. There is a provision in the BNSS which says that kindly 105, and the lies will be demonstrated if they show the video. Take 105 of BNSS. We are also very disturbed, Maharaj. Extremely disturbed as to what is happening. Why should ED, Maharaj, wait for 2 years to come to West Bengal and go to an office which is a party office, which has all the data with all the information? It's part of party office. Kindly see 105. The process of conducting search of a place or taking possession of any property, article or thing under this chapter, or under 185, including preparation of the list of all things seized in the course of such search and seizure, and signing of such list by witnesses, shall be recorded through an audio-video electronic means, preferably mobile phone, and the police officer shall without delay forward such recording to the district magistrate, subdivisional magistrate, or judicial magistrate. Please show that recording. Everything that is in the statement will be proved to be a lie. That respondent number 2 took all the devices. It's an absolute lie. And it's contradicted by their own Panchnama in this petition. I read the Panchman out to you. This is very unfortunate, Mullahs. And that's why, in a matter of this nature, Mullahs, and I'll come to the law a little later, Mullahs, this is just to create prejudice. Now kindly come to the Panchnama. 66, Mullahs. I'm going to show you. Page 66. Mullahs, kindly come to 66. We above named Panchas. Your Lordship sees that? And yes. Kindly come. They show that search was conducted. Now kindly come to 68. Yes. Kindly see. During the course of the search, so and so inquired about the ongoing proceedings. At 12:05, Mullahs. Search started in the morning. No seizure took place. Till 12:05, no seizure took place. And inquired about the ongoing proceedings, informed her about the proceedings. At around 12:15, took possession of material being seized via laptop belonging to Pratik Jain. Now, laptop belonging to Pratik Jain will have all the information about the election. Every piece of information. Several documents and iPhone Pro belonging to Shri Pratik Jain left the premises. Several documents. Where are all the devices? He just read in the petition that she took away all the devices. Contradicted by their own Panchnama. An iPhone. She took the laptop which would have the party information, and she took their personal iPhone. That's all, nothing more. And then see for third paragraph. The search was proceedings commenced at 6:20 on 8/1/26 and concluded at 2:50 on the same day. The search was conducted in a peaceful and orderly manner, and no damage to any person or property was caused during the search. The entire proceedings were conducted in the presence of the lady staff and whatever. There was no obstruction. And signed by ED. So where is the government in the petition is contradicted by their own Panchnama. Normally, what's interesting is there's another Panchnama at 73, because then they go to the other office, which is at Salt Lake.
Another party office.
It has party material, election material, which you are aware of, which is why you went there. It is a completely mala fide act on the part of the ED to disturb the process of election and to gather as much material as they can from the office, which has all the material, which is through a contract, which contains all the confidential material. Now kindly come to see the second Panchnama. 74 bottom. During the search proceedings, Ishant Taneja, Pavan Verma so-and-so, and other employees joined the search proceedings. They were also explained the purpose of the visit by the authorized officer. Meanwhile, Shri so-and-so joined the search proceedings. He also offered personal search. Officers started the search proceedings in our presence in a peaceful manner. Nothing was seized. Nothing was seized there. Nothing was seized here. From the premises, and no data backup was taken by the team of Director of Enforcement. And the search proceedings concluded at 6:45 p.m. on H1, documents available in the different sections of the premises were not mingled with each other, and the same was left in a proper and orderly manner. These facts were duly acknowledged. That's it.
Contrary to what you are submitting.
I'm sorry?
They had the intention to collect materials from your party office. They would have seized from
They were
you.
just photographing.
Didn't seize anything.
They don't have to seize it. They can
Didn't seize
photograph.
anything.
They can photograph it. They don't have to seize it. But your lordship
Their
knows.
Rajnama says they have not recovered anything. If they had
Well, why did they?
any intention
Malaj, what?
of seizing your material belonging to your party,
Malaj,
they would have seized.
we are not discussing.
They have not seized.
Malaj, these are facts which will have to discover, which will have to be dealt with, Malaj, in a writ petition.
We have to examine.
Malaj,
You file counter, we'll examine
no,
this.
no, Malaj, just.
No, you cannot restrain us from issuing notice.
I'm sorry, of course I can't, Malaj. I can persuade your lordship, that's all. That's what I'm trying to do, Malaj.
Yes, please.
I'm only trying to show you
Yes,
the Panchanamas certainly demonstrate that there was no untoward things that happened, both at the residence of Jain as well as in the office of IPAC. Kindly have a look. So the Panchas, Malaj, and the Panchnama doesn't say anything of that sort, Malaj?
Yes, yes.
Right. Now, the other question, one question is, Malaj, and I told your lordships on 24th February 2024, Malaj, the last statement in this coal scam was recorded.
Yes.
Then why was there the need to go in
That's
2026?
wrong, factually wrong.
I have got it. I've got it here. Why do you say it's factually wrong?
From the
That's
record
here.
of the investigation.
No, we have it.
Last instance.
We have it here. 23rd of February.
We are conducting the
23rd of February.
No better.
You have given these details to us. Your petition. Your petition, you say that 23rd February, Mukesh Thakur claims he transferred the money to Goa at the request of Jitendra Mehta, a financier of Aks. That's it. After that, no statement. It's your petition.
That is at page.
Para 12 itself, page 104.
We don't
just read it.
All evidence at this stage, Manoj.
Ari, you have your
recorded in
your
December 24.
Again, you are interfering. I'm taking your petition. Well, kindly come to page 8. F.
Page F.
Yes. S. Okay, I'm sorry.
Which one?
Whatever you give me.
Director of Information.
Yes, you give me.
1 July 2020.
CBI furnished CBI furnished the second supplementary charge sheet in the proceedings emanated from FIR on 1/7/2024.
Last date, 8/1/26. Concrete material found during investigation.
That's right. So that's precisely the case. That from
2026.
That means 2024. Why would you were doing nothing? Suddenly in 2026 you find material.
On the lighter event, what Mr. Tushar Mehta is suggesting, if money is laundered only during the election, what is their fault?
There is no election, Malodi.
That's why this relates to Goa.
That ongoing election. Which election?
Solicitor, you are such a good person. Have the patience to hear us.
My learned friend disarms me.
Well, you're right. There is no election in Goa.
This is not Goa. This is Delhi.
No. This is where Goa money transferred to Goa.
My learned friend said during election, why did you
during
go for
election in West Bengal?
There is no election in West Bengal.
Oh, I see. If this is the level of knowledge, Maharaj, that emanates from the solicitor, there's nothing I can say, Maharaj. That there is no election in West Bengal. I'm sure it does.
He's yet to be notified what he's saying.
He can say that, Mullah. He's a very precise lawyer. He's very careful with his words.
I am, my lord. Therefore, I am saying there is no election. Your premise is wrong.
Absolutely, there will be none.
And my lord, only one line, my lord. Allow me to interrupt. Lord, if the ED officials go to their party office, it's not a party office, it's an office of a strategist kind of a, according to them. What would a normal person do? Please give me a minute. This document have two sets.
One second.
One my party thinks and another maybe else. Another you can go, but allow me to take my party details. You have nothing to do with this party details.
The solicitor seems to have
just takes everything which is shown in the media with files and everything, that I have taken everything. Otherwise, if there is a scrutiny, so no, this is my party.
Everything that he says has to be accepted. More than why are we here? Maybe because he keeps on interfering, says what he wants to say, as if this is the gospel truth. It's not fair. It's not fair on us. Now, let's kindly see page 38.
1 minute. I'm there in the second petition.
But no, one second. Allow us to finish. Allow us to finish.
This is not to be seen.
No,
correspondent argument. 2 minutes at
We
least.
are arguing only first petition.
Very well.
I'm arguing only the first page. Now, kindly see page 38.
You will be allowed to argue.
The second is, yes.
Kindly see page 38. Kindly see page 38.
38.
Yes.
See, there is some circular issued by the Honorable Chief Justice about time schedule.
Yes. You must
should apply to.
Yes, and interruptions, but both.
To motion hearing also.
Both.
To regular hearing.
The moment. Yes, but Honorable Chief Justice also should issue a circular that lawyers who are appearing would not discuss that matter in public forums like press conferences. That is also.
That also, Malaj, that the CBI should not be leaking information and the ED should not be leaking information.
Yes.
No, to journalists of their liking. Therefore, there should be a ban on that also.
Yes, I'm ready to show, Malaj, what I've stated.
You can show it. You can show it.
This is not the
narrative.
That's why my learned friend always he's very upset at the fact that I do some program, Malaj. He seems to mention it is every matter he mentions this, Malaj.
No,
you should watch it a little more. You'll understand a bit.
Programs. Don't discuss matters. Don't discuss matters which were.
I'm entitled to.
I have not seen any.
I'm entitled to.
No,
I'm not entitled to. Well, he knows about it.
Mr. Mehta is increasing the circulation of this program now significantly.
No, it is
without watching it himself.
Malaj, page 38. Let's move on to the matter.
Yes, 38.
Yes. Now, what are the offences, Malaj, that are alleged?
Yes.
Yeah, it's all 37, but the offences are all these offences: abetment, criminal conspiracy, voluntary causing hurt to public servant. No such thing. It's on the face of it. In their own petition. Wrongful restraint. No statement of that sort. Wrongful confinement, force, criminal force. What is all this going on? 1/3 assault on criminal force, obstructing public in discharge, omission to assist public servant when bound to give assistance, disobedience to order duly promulgated, theft in dwelling house, theft after preparation made for causing death, hurt or restraint, robbery, dacoity, criminal trespass and house trespass and housebreaking, house trespass in order to commit offence, causing disappearance of evidence, destruction of documents. What is all this? This is all contrary to what is in the Panchnama. How can all this happen? And Malaj, all this has to be done how? Under 66(2). Under 66(2), if there is any offence, it has to be reported to the investigating agency of the state. Your Lordship knows 66(2). I'll read it to you. How can all this happen in a writ petition in the 32? Can you see 66(2)? 66.
We have gone through that.
Sorry, a PMLA.
PMLA. I
Yes.
866.
Yes. No. 66(2) of PMLA. I read the offences to you just to indicate that all this cannot happen in a writ petition.
No, it has not happened in a writ petition. It has happened there.
No, he is saying these offences have been committed and therefore they have to inform under PMLA if the director or other authority. Just read, Malaj. If a director or other authority specified in subsection 1 is of the opinion on the basis of information or material in his possession that the provisions of any other law for the time being enforced, that is IPC, these are IPC offences, are contravened, then the director or such authority shall share the information with the concerned agency for necessary action, which is the state agency.
FRCPA investigation is
So, Malad, so what they are saying is these offences are committed. They say now you must charge them with these offences. We have filed a writ petition, whereas under the statute they have to inform the agency of the state that such offences have been committed. Please investigate. They can't ask your lordship in an Article 32 to do that. And they are choosing the agency which is being accused by us for mala fide searches. And then, apart from all that, and I'll let my learned friend take it forward, Malas, apart from all that, Malas, the question is, why should the High Court not hear the matter? High Court is not disabled to hear the matter.
I'll take
So we'll take our submission.
I'll take
only one
Mr. Please allow correspondent three minutes.
Not on the merits. But one response to Mr. Sibbal, a very respected. I personally, he knows I respect him. My objection to matters of arguments being debated elsewhere is not only against Mr. Sibbal.
It's also
everyone.
It's also against
who appear.
Yes.
In the matter should not give press conferences and give media interviews justifying or creating a narrative. That's in principle, not in this.
In principle, my learned friend should have no objection. In principle, he should have no objection because he knows that that's not the law. Once a judgment is delivered, it's public property. And this court has said that once it is public property, it can be discussed. And he knows the law, but he doesn't want to reveal that he knows the law.
No, my lord, the incident in question, there is no judgment in law and narrative building.
My learned friend is wrong. There is a.
I leave it at that.
There is a.
No, can I?
I leave it at
3 minutes. I heard my lord's wills, but my lord's.
No, we have the entire, about second half bench is cancelled.
I'm in that matter, Wills. It was mentioned without telling us. That bench, Justice Amanullah and your lordship.
Sir, I do not know your loss, but your advocate on record was informed.
But then let me, my lord is saying something. Let me
present.
It was cancelled by the bench, by the court, not by the any
I was
request of
told
any.
somebody mentioned it, he told us after.
No, my lord, we mentioned with presence of his advocate on record, with consent.
What Mr. Singhvi said.
I can apologize.
In fact, the court said that we'll fix a date later.
He should have been heard before cancelling the bench.
No, I should know it.
Understand why?
Yes.
They have long confidence that they do and they should put
Can be deemed as having been heard, my lord, for all purposes.
Anyway, with this,
So in that bench,
all these
that
digressions.
bench he said, 2 p.m. bench, that he should have been
I know
heard.
Justice Amanullah's bench. Anyway.
That it should have been
Let me
recorded
come
in the
down.
order sheet that he has heard. Yes, next. Please.
Because people come and have long conferences, discuss matters, and suddenly they mention without telling us. That's why I was complaining.
Yes, you are right.
Anyway, Willis.
You are right.
Now I'm going to make 3 or 4 points in less than 2 or 3 minutes, Willis. One is we have serious objections to the maintainability of this so-called Article 32. In the highly unlikely event that your lordship issues notice, your lordship should make it clear as a caveat that it is subject to a very strong preliminary objection on maintainability, which shall be alive.
Yes.
There are judgments which say that an ED or a statutory body like the ED coming straight into a walk-in system of 32 requires very grave consideration. It is allowed in exceptional circumstances where, Malas, it is necessary that the ED is virtually remediless. That's the test. That's point number 1. I propose to raise it, Malas, strongly, both today and in any eventual hearing.
You are agreeing for state of.
I am for 1 and 3, state and police, state and DGP. 1 and 3, he's for 2. Point number 2, Malas. I also intend to raise the preliminary objection of forum shopping with your lordship's well-known case law. Because what your lordship is concerned about is that this petition is filed after my learned friend files an identical petition. Lordship will take my word for it. The prayers are virtually identical.
We are in High Court and here.
In High Court and here. Lordship need not waste time seeing it. Lordship will take my broadly, substantially, it's identical.
Yes.
Now you are the petitioner there, you are the petitioner here. Yes, you had a fracas on a certain day, on 9th. That cannot be an excuse to maintain a parallel riding 2 horses.
Why should it happen at
No,
all?
Malas, that's a different issue. We'll answer that. I understand my lord's concern. And don't think I don't appreciate my lord's concern. I don't think any of us hold brief that should.
Today it is this High Court, tomorrow the
No,
some other High Court.
sometimes emotions go out of hand and they can't be controlled. Please don't misunderstand me that I'm not understanding my lord's concern, and that I don't think anybody will hold a brief. Perhaps emotions go out of hand and we are not able to control. But the relevant test is yesterday.
No, you see, emotions should not go out of hand regularly.
In an orchestrated manner.
And then on 9-1, again, emotions go.
Now, may I just say, we are now talking of R1 and R3. I am saying this, that the relevant date for considering forum shopping is yesterday. I understand. I am not belittling what is falling from my lords. Keep that 9th apart for just 2 minutes. Yesterday, everybody was in court. It is not even your case that anything untoward happened or was attempted or even started. Why on earth, you having filed your own petition in High Court, the next day having filed in Supreme Court or 2-3 days later filed in Supreme Court, then make a statement to the High Court yesterday, please don't hear me, and the High Court is forced to pass such an order. It is not that you are getting this date yesterday because of the ruckus. Kindly give a copy now. Why don't you give a copy? One copy. So, in effect, the High Court is told, I am riding 2 parallel horses. I am telling your lordship I am riding 2 parallel horses. But you please stay your hand. And the High Court records this order, 1-page order. I am adjourning it sine die. Obviously, in Committee of Courts and Superior Court and all that, it's the right thing to do. As far as the High Court is concerned, I am not blaming them. I am on the conduct. So this is forum shopping. I again take this strong preliminary objection. My third submission is the Panchnama, which has been read. That has been read, I am not repeating it, but just note the relevant words, only the operative words, 3 lines, which Lordship has seen, Panchnama, which has been read already. It's been read, but just the relevant lines, that 66 to 69. 66? Yes, 66 to 69. These words are important. That's my third respectful submission.
That page?
Well, it's at page 60. This particular portion is which page? 68. 68. You are showing the first line.
Yes.
Please, you don't know the thing. If your lordship has just the penultimate para at 68.
Yes.
This is relevant. Ultimately, what is relevant is this, to tell you that he snatched the papers, he ran away, he did this, he assaulted somebody. What is relevant is this, either you are lying or your petition is lying. Third, penultimate para, second line.
Yes.
The search was conducted in a peaceful, orderly manner. Each word is important. No damage to any person or property was caused during the search. Entire proceedings were conducted in the presence of lady staff and no religious sentiments.
The learned friend may read the 2 paragraphs above.
What peaceful means? Peaceful from their side.
They mean to say 2 paragraphs above what my learned friend.
It is side, not from your side. That is what
I'll read whatever you want me to read. I'll read it, Bullet.
Not the relevant section. Let him.
Yes,
they have done it peacefully.
No.
Let him read the 2 paragraphs.
Previous para which he's asking
2 paragraphs above.
face.
Respond may not
Mr. Raju, please.
Let him read.
It is not denied by our.
Dictate Mr. Raju that what he is reading.
We didn't interrupt once even, Malak.
Yes,
it took a long time.
Please,
Mr. R2, Mr. Sibbal, has admitted that the CM was, the president of the party was there. So what is so great about this para? This para says that so-and-so time, so-and-so Miss MB took possession of the material, etc., etc. That's all. Nobody is denying that she was there. Now, these are derailment. I am at a different point. I am saying that with this Panchnama, what you are projecting in the petition is either clearly false or your Panchnama is false. That's all I'm saying. This para is standalone, clear. Obstruction, could not do this, could not do a search, all wrong. Now, the fourth aspect is very important. My learned friend, I heard Mr. Mehta making what again is I can ascribe to mildly to wrong instructions. He said we informed them, and I believe I heard the word yesterday. The day before the event happened. I may have been wrong, I may not have heard you correctly, in which case I am wrong. Well, it's the first and only intimation came from a casual email at...
Email can't be casual and non-casual. That's what the intimation was by email.
Have you heard my sentence fully? No, have you heard my sentence? You realize? You don't be presumptuous, Mr. Mehta. You started your search at 6:45. The email is 11:30. In which calendar, from which Gregorian or non-Gregorian calendar does 11:30 happen before 6:45? I'd like to understand that. So before you interrupt, get your instructions right. You're only, that's why I say, obviously, if I'm searching his house and I send an email 11:30 to create a paper trail, I started searching the house at 6:45, 5 hours earlier. And my learned friend says it was beforehand informed. In the middle of Balas, the persons are there. Some police officer will go start reading emails. 5 hours earlier, event has happened. So this is a very clever way to cover up your tracks. A person who sends an email 11:30 for a search which starts at 6:30 is covering up his tracks, creating a paper trail to tell your lordship later on. My next point is, Balas, that the question he raised, I'm only answering that, but I'll have to put it down if necessary. I came there because a Z protectee, a Z class protectee, was informed in an FIR number 5 of 26 that unidentified persons who refused to identify themselves had entered this place and were dealing, and the Z class protectee had reached there. So naturally the police rushed there. That's all that happened. Now, Malats, the ED officials identified themselves much later. They did not identify themselves because the only identification would be a prior written intimation at 6:45 that I am Mr. A, Mr. B, Mr. C, we are going there at this time, or at least just before that. So, Malats, that is why I went there. That is nothing sinister about that. And whether she is a chief minister or a president of a party, she remains a Z plus protectee. So, Malats, the moment we come to know, we have to move. Malats, in the light of this, your lordship may consider, I leave it to my lords, that Malats we put in, if your lordship is so inclined, without notice also we can put in a reply saying these points. Otherwise, Malats, I leave it to my lords.
Otherwise, you will say 6:25 p.m., 11:30 p.m.
No, I will put in these things. Your lordship wants me to put
legal
in.
Things should
So
be
there
done
are other respondents also.
should be done in a legal way.
Anyway, I don't know. That's all I have to say.
Yes. Yes. You're for?
I'm appearing for respondents 4 and 5.
Sorry.
In first petition.
Yes,
Because we are yet to hear the second petition.
it's in both the, it's in both the.
No, Mr. Raju wants to argue the second one.
First petition.
First petition, respondent 4 and 5.
5, yeah. So I just have a very small point. Your lordship may just consider that the appropriate order perhaps in a case or a situation like this, your lordships have seen that the hearing which took place on the 14th was in a very orderly manner. So I would respectfully submit that that is the subject matter of a 226 petition. Let that matter proceed. The lordship wants to reinforce because the Chief Justice's directions are very clear. It's proceeding in an orderly manner. It ought not to be, that's my suggestion, that the 9th January disruption which took place when the court itself could not hear the matter, that shouldn't have a lingering effect which persuades this court to issue notice under 30. So let us see what happens, my lords, on the adjourned date or the next date as far as the 226 is concerned. If that proceeds smoothly, as it will, I mean, we expect that it will, that's a much better way of going about it, my lords, rather than this. I would respectfully submit that statement, at least at this point.
Yes, Mr. Raju.
There are several submissions that I have to make. The first submission is the recording of an FIR only requires that prima facie a cognizable offence is made out. If the averments in the petition make out a prima facie case that a cognizable offence has been made out, that's the end of the matter. Lalita Kumar is very clear. No inquiry is required, no accused is required to be heard. Their defense is not to be considered.
That's about which FIR?
I'm asking for the FIR, which I'm asking to be registered and CBI investigation.
Oh, yeah.
For that, I'm making my submissions. So if my petition discloses a cognizable offence, then a FIR has to be registered. Nobody hears an accused before an FIR is registered is unheard of. We have made them respondents by way of abundant caution. That is what we have said without conceding the right. That is my petition says. I've said that in paragraph of my petition. I'll read that paragraph. This is one paragraph. Now, therefore, the issue that arises is, has a cognizable offence taken place? On admitted averments, the offence of cognizable offence has taken place because an offence of theft. I have pitched my case a little higher. It is not only theft, it is robbery and it is dacoity, because more than 5 persons were there. Some policemen were armed and there was wrongful restraint. But forget that. Simple case of theft, which is a cognizable offense, is made out on admitted averments in my petition. If that is so, the issue is who should investigate. If a cognizable offense, FIR has to be registered. That's the settled law in Lalita Kumari. May I read Lalita Kumari? Or
yes, read.
Give me Lalita Kumari. Come to bed. But kindly.
Continue.
I'll not take much time, but I'll only make, kindly have a look at para.
You argue, we have no difficulty.
Kindly have a look at para 120 onwards, conclusions.
Yes.
By
Para 5.
120.
Para 120.
At page 61. 120.1. The registration of FIR is mandatory. Kindly note my mandatory under section 154 of the code. If information discloses commission of a cognizable offence and no preliminary inquiry is permitted in such a situation. So if the petition discloses a cognizable offence, it is mandatory that an FIR has to be registered.
Para 120.1.
Yes. I have demonstrated that a cognizable offence has taken place. One doesn't say that you have to inquire from the accused why you have committed the offence of theft. That is not the scope of registration of FIR. You have to look at the averments made by the informant, in this case in the petition, and if it prima facie makes out a case of theft or a cognizable offence, FIR has to be registered. Therefore, whatever they are saying, we went there because of a party document, which is wrong. Otherwise, no FIR would be registered. The entire purpose of the scheme of the CRPC would be frustrated. This is number one, Manoj. The second is, ordinarily, I have to go to the local area where the offence has been committed to get the FIR registered. But this case stands on a different footing. Your lordships have permitted deviations from the normal rule. Why the local police should not be permitted to investigate? Here, the chief minister is an accused. She is the person who has personally committed the theft. This theft was committed in the presence of the Director General of Police, who could be an abettor. It has been committed in the presence of the Police Commissioner of Calcutta, where the offence has taken place. So, head of the police in West Bengal is accomplice as far as the offence is concerned. Police Commissioner is an accomplice, and she is the Home Minister. So, no FIR, if it is registered, even if it is required to be registered, will be inquired and investigated properly. Now, the law is, kindly have a look at 3 judgments. In this case, if the highest authorities are involved, then the CBI investigation is to be ordered. But kindly have a look at, one is K.V. Rajendran versus Superintendent of Police, 2013-12 SCC 480. 480.
480. Para?
Para would be 17. Where they say if the
70.
17. It is extracted at page 31 of my petition.
Page 31 of your petition?
Yes, of the first petition also, my lords, we can have a look at it. In view of the above,
Page 480.
page 31 of my petition, my lordship got it?
Yes. 481.
480 para 17, my lord.
13, 12.
I can hand over a copy of syllabus.
No, we have
In view of
para 17.
7.
In view of the above.
In view of the above, the law can be summarized to the effect that the court should exercise its constitutional powers for transferring an investigation from the state investigating agency to any other independent investigating agency like the CPI only in rare and exceptional cases such as where high officials of the state authorities are involved or the accusation itself is against the top officials of the investigating agency, thereby allowing them to influence the investigation, and further, that is so necessary to do justice and instill confidence in the investigation, or where investigation is prima facie found to be taken. This is at the stage of investigation, but prior thereto also it can always be excised. Then kindly have a look at the second judgment, my lord, 2014, 8 SCC, page 682, para 86.
Oh, then 14.
2014, 8 in SCC, page 682.
Last but one page, but no, just for easy reference. Last was third.
It is the para 86, Supreme Court page number is 736. The criminal, it starts like the criminal justice system mandates that any investigation into the crime should be fair in accordance with law. So if it is investigated by the accused or somebody subordinate to the accused, it can never be fair.
Yes.
In accordance with law and should not be tainted, it would be tainted. It is equally important that interested or influential persons are not able to misdirect or hijack the investigation, which would be the case if the local police are asked to investigate, so as to throttle a fair investigation, resulting in the offenders escaping the punitive course of law. These are important facets of rule of law. Breach of the rule of law, in our opinion, amounts to negation of the equality right under Article 15. Therefore, my lord, I can come here directly because otherwise my right under Article 32, fundamental right under 14 would be infringed. Therefore, I can come directly to this honorable court, even under 32. No need for me to go before the High Court. Then, my lord,
Why can't you continue in the High Court?
I'll tell my lord why.
You answer it after we come back post lunch.
Very well, I'll answer.